Hi there, this is Doug Zanes. I'm the owner of Zanes Law, which is a personal injury law firm with offices in Tucson and Phoenix, Arizona. And I want to welcome you to my weekly show. I appreciate you tuning in this week. This week I want to talk a little bit about slip and fall cases. I think it's pretty self-explanatory when I say that. I think most of you guys who are listening know that when I say a slip and fall case, I'm referring to basically when somebody is walking along and falls down and gets hurt, and they want to bring a claim against the party who they feel is responsible for creating whatever the situation was that ended up getting them hurt. And so I want to talk about it a little bit because, quite frankly, we get lots and lots of slip and fall calls pretty much every single day, and people get severely injured when they fall, unfortunately. In fact, some people, if you fall the wrong way and hit the wrong thing, I mean, people are killed in slip and fall accidents. And so they're serious injury accidents. They happen more often than I think most people realize. And there are lots of circumstances where somebody really isn't responsible. And it's important that everybody listening to this realize that. I mean, I think there's a tendency to believe that if I'm at your store, if I'm on your property, and I slip and I fall down and I get hurt, you're responsible because I'm on your premises. And it's not quite that clear cut. Now, so I want everybody to understand that and sort of start from that point. But having said that, I mean, we represent lots and lots of people every year who are hurt in falls, who we are able to get compensated because somebody else is ultimately responsible for their fall and their injuries because of negligence on their part. And so let's sort of start from there. What is it that we need to show in order to prove that either a property owner, the company that has the business in that on that property, the homeowner, whoever it is who we think is responsible, what do we need to prove or to show in order to be successful? Because just saying we've got to show that they were negligent doesn't really explain much. And so one of the things we've got to show is that the person who we believe is responsible either knew or should have known about the dangerous condition that existed that caused you to fall. So that's step one. We've got to prove that they either knew or they should have known about that dangerous condition. The next piece we have to show, because quite honestly, this is sort of a defense. If we can prove that the property owner, whoever we think is responsible, either knew or should have known about the dangerous condition, one of the things they will typically argue as a defense is, well, even if we knew or should have known about it, the condition wasn't unreasonably dangerous. And if they can convince either a judge or a jury of that, we may not be successful. Because it really, if it's not an unreasonably dangerous condition, it's going to be a difficult case to win. And, to kind of put that into perspective, I mean, what is the difference between a dangerous condition and an unreasonably dangerous condition? And I think the way that I've always looked at it is just about anything under the right set of circumstances can be dangerous. Kind of the wrong place at the wrong time scenario. For example, if grass has been watered and is wet and you walk across that grass, and you slip and you fall and you break your leg severely, well, You can probably show whoever's watering the grass, whoever owns the property, either knew or should have known that the sprinklers were kicking on at, let's say, 1 in the afternoon. You can certainly argue that they also should be aware that that can be a dangerous condition, because when the grass is wet, if somebody's walking or running across it and they slip and they fall, they could be hurt. But they will come back and say, look, maybe that's all true, but it's not an unreasonably dangerous condition. It's simply wet grass. Whether we water it, whether it rains, it's simply wet grass. So we shouldn't be responsible. And the defense will probably win that argument. And so that's why that distinction between dangerous and unreasonably dangerous, I think, is important. And then the other thing that, whoever you're bringing your claim against will argue as well is that, assuming it applies, but in a lot of slip and fall cases it does apply, is that whatever this unreasonably dangerous condition is, it was open and obvious. Meaning you, as a person who fell, should have been able to see it and avoid it. So let's say they dig a 10-foot hole. So the property owner knows of this hole because they dug it or they had somebody dig it. They didn't put up any barriers or any signage or anything, to kind of protect somebody from falling in it. So that can help you argue, hey, look, a 10-foot hole just out there all by itself in a place where people are walking is unreasonably dangerous. They knew about it, so they're responsible, but they will also come back and argue, hey, look, it's open and obvious. How could you not see this big giant hole? And if you could see it, why'd you walk right into it and fall 10 feet and, break both of your legs? And if they can convince somebody that it's open and obvious and you should have seen it, they, quite honestly, what they're doing is they shift the blame from them to you. It's actually a defense that, at least in Arizona, property owners have when it comes to these types of cases. And so that's an important piece. And so, I think just from listening to it up to this point, you can understand how much more complex a slip and fall case is than I think what most people realize. Most people, again, think, hey, look, I slipped, I fell, I got hurt. You need to pay. You need to compensate me because I was in your driveway. And it's not that simple. So we're going to kind of start from there. And let me talk about a couple of kind of examples of cases we regularly see. First example is going to be of cases we see pretty often and find very difficult to be successful on. We talk to a lot of people, quite honestly, who slip and fall walking through a parking lot. So you're outside; it's an outdoor parking lot. You generally have, most of the time, asphalt is kind of the ground that you're walking on. And, the potential clients who call us will, typically have fallen because they've, stepped in something slippery, let's say like grease or some sort of fluid that's leaked out of an engine because it's a parking lot. A lot of people we've talked to over the years have slipped in sand or dirt that's, in the parking lot on the asphalt. And then we've certainly talked to people who have, for example, tried to step over a parking curb, caught their foot on it or their toe on it and fell, those types of things. People who are walking through a parking lot. Most parking lots will have light poles in the middle of the parking lot, and they happen to, they're just maybe not quite, paying attention, and they, catch one foot on the base of the light pole, and that causes them to fall. And so, and then you have things like potholes in a parking lot that you maybe step on and fall. So most of those scenarios that I just laid out, it's going to be very, very difficult to be successful on. And again, I get where somebody who has fallen, I understand what their perspective is, which is, let's say it's dirt in the parking lot. Well, doesn't the property owner have a duty to clean the parking lot? And I think the argument is certainly valid. I mean, I think to a certain degree they do. But if you're talking about dirt or sand in an outdoor parking lot, you know, when you talk about a duty to clean, I think it's much different. I mean, if it, yeah, if you take a parking lot that's just loaded full of all kinds of junk, boards, tree branches, garbage bag, all kinds of stuff that people dump out there, and the owner of, let's say, the local grocery store doesn't have somebody come and haul it off, then yeah, you probably have a reasonably good argument. But that's not what we see. I mean, you can go down to any parking lot at any mall or any grocery store and look on the ground, and there's dirt and stuff, papers and some little things, but there is, in my experience and what I've seen, it's not unreasonably dirty. Now, again, every case is different. You've got to look at every case individually based off the individual facts. So you could have a case that you could be successful on, where you slipped and fell on some stuff in a parking lot. But most of the ones we see, somebody's walking along, there is some dirt, there is some sand, they happen to step, unfortunately, just the wrong way, wearing the wrong shoes, their foot slips out from under them, they fall and they hurt themselves, sometimes severely. Those cases are very difficult to win. Cases where you trip over a parking curb, very difficult to win. One, it's a parking curb, and the argument is you should have been able to see it, so you could have easily walked around it instead of tried to step over it. So it's open and obvious. Two, they're going to argue it's not unreasonably dangerous. You see parking curbs everywhere. They're in lots of parking lots. So it's a tough fight to win. Things like potholes can be different. Again, you've got a duty, or the property owner arguably has a duty to maintain the asphalt as it becomes worn down, as it ages, as it becomes weathered. They have a duty, with all the foot traffic that comes through that parking lot to visit their stores, to keep it safe, to repair those potholes. And if they don't, and you fall, then you have a much better argument. So that's one example that we see regularly, and kind of the ins and outs from our perspective. If you're inside, let's say, a store, we talk to lots of people who unfortunately just slip in a puddle of something in the middle of the floor, middle of an aisle in a grocery store, just the open middle of the floor somewhere. And those are very difficult cases to win. What we always say, or what I always talk to our attorneys about looking for, is a mechanism. And what I mean by that is this. Generally, I want to be able to show, again, that there was something that the store either knew or should have known about that would create that liquid, and they didn't fix it or change the situation. So what I mean by that is, for example, if a cooler or an air conditioner on the roof is leaking, and that's what has created the puddle in the middle of the aisle. Well, the store either should have knew, or the store either knew or should have known that their AC was leaking, and they should have fixed it, and they didn't. And at the very least, they should have made it clear to all their patrons, hey, something's leaking from the roof to the floor here, so don't walk here. Or a Coke machine that's leaking. That's a mechanism. The big ice cooler at the front of a grocery store. Next time you're in a grocery store and you're walking by the ice machine, I want you to look. A lot of stores on the floor will have these big sort of rubber mats that have holes in them, big thick rubber mats with holes in them. And that's because as you take ice bags out of the ice machine, inevitably, somebody's going to pull a bag out and some ice cubes are going to fall on the floor, and that allows the ice to melt and the liquid to kind of run down on the floor. When somebody walks across it, they're walking across the rubber pad that's in front of the ice machine, so they don't slip and fall. So what happens is, you'll come across a store for whatever reason that doesn't have that big rubber mat. Maybe it got worn out, so they threw it out. Maybe the cleaning crew forgot to put it out, but it's not there. And it's wet in front of the ice machine, and our client was walking in front of the ice machine to leave the store, and they slip and they fall and they get hurt. And, so we can win those fights, and we've won a lot of those fights. And on top of that, generally the ice machine is close to, the front checkout area where there are lots of employees, customer service people, and all of those things. So again, they should have seen it. They either knew or should have known it was an unreasonably dangerous condition that could have easily been prevented. They didn't do what they needed to do to fix it. Our client fell and got hurt. They're responsible. So that mechanism I'm looking for. Another type of case that we've seen regularly and won regularly is, lots of times on weekends, grocery stores will set up, meat stations or seafood stations, out either at the front of the store or separate from sort of the meat and seafood department because they're having a special. So what they do is they have this big setup, big tables set up that are loaded full of ice, like ice chips or ice pellets, and they have their fish or their meat on there, and they're selling from there. Nothing wrong with that. That's perfectly reasonable. But the store created that area. And they created it knowing that they're putting out a bunch of ice chips or ice pellets, and that realistically, throughout the day, some of that ice will slip off or fall off onto the floor. So they need to keep it cleaned up and pay special attention to it. And they don't, and we have a client walking by and they slip, they fall, they get hurt. Those are good cases. So those are the things we look for. If you just have a puddle of liquid in the middle of an aisle, and that's it, those are very difficult cases to win. Because the store is going to, one, argue that they didn't know and there was no reason for them to know. Because it's just in the middle of, let's say, the aisle where they sell charcoal and paper cups and paper plates, and why would they expect to find a puddle of water there? On top of that, they're also going to show, stores generally do as part of their, what they do every hour, and they'll generally do it a number of times during the hours, they do sweeps. Now what that means isn't that they go actually sweep up and down the aisles with a broom, but it means they walk by each aisle on the very end and they look down the aisle. And they're looking down the aisle for a bunch of debris, or stuff that's in the aisle, for, something that's dangerous. They actually go and they look, and if they don't see anything, they move on to the next aisle and they look down it. And if they see something, they walk down, they check it out, and they call the cleaning crew. So they're going to produce those sweep records, and essentially what they're arguing is when we walked by at 1 o'clock, that aisle was perfectly clean. Then when Mrs. Jones slipped and fell at 1:10, it was because at some point after 1 o'clock and before we could do our 1:15 sweep, somebody spilled a bottle of water. But we did our due diligence. We did what we were supposed to do. And again, they'll win that fight more times than not. So those are kind of some of the important ins and outs of slip and fall cases. So they're not easy cases. They can be very complicated. We've got a number of fall cases right now, and have a similar cases just like this over the years where our client falls in a store, and you have actually two different groups blaming each other. Perfect example would be, we've had cases where they're doing some sort of construction within the store. And so there's actually a hole in the floor in the store that wasn't, cordoned off the way it should be, wasn't very visible on top of, and so our client goes walking, falls in the hole, gets hurt. Well, you have the store blaming the construction company blaming the store. Meaning the store says, hey, look, that's the responsibility of the construction company. Before they left for the day, they were supposed to put all their signs up and, do whatever, they have to do from a safety standpoint. And the contractor says, hey, we did it all. But some employee of the store must have moved it or changed it. And so everybody points a finger at everybody, so you have to go sue everyone and work it out over 2 years of litigation. But that's just part of how these cases work. Another example is we've got a case right now, actually, where a client's walking down the freezer aisle of a store. You have a vendor, somebody who, I don't know what he was stocking the freezer with. It was, let's just say for argument's sake, say frozen pizzas. And our client was walking by, and there was, it was wet because of the product that this guy was taking in and out of the freezer. And that it was wet because, it was an icy or frozen product that had melted some, and so there's liquid on the floor. Client slips and falls, gets pretty badly hurt, and the store blames the vendor blames the store. And so again, we go sue everybody and go work through the process. But point is, they can be very complicated cases. There are built-in defenses for whoever you believe is negligent, and that's either that the condition was open and obvious and you should have seen it and you should have avoided it, and by not doing so, you're the one really responsible. Also, that the condition wasn't unreasonably dangerous. The third would be that they didn't have any knowledge of it. There was no reason that they should have. And so, those are the basic ins and outs of a slip and fall case. And again, there are lots of other premises liability type cases that have nothing to do with slip and falls, that have to do with things falling off of, from above and hitting you. Home Depot has had lots of claims over the years when toilets are very heavy, dangerous things that are stored up high on a rack, aren't secured correctly, and they fall off and land on somebody and severely hurt them or kill them. We've had plenty of cases where things like that have happened in one way or another with all kinds of different companies out there. And so, I just want you to understand the basics. And certainly, if you have any questions, you can send me an email at dzanes@zaneslaw.com. I'll be happy to get back to you. But kind of the parting thought is this. If you fall down and you get hurt, it really is in your best interest to talk to an attorney and get their insight. But you need to do a couple things. One of the things you should do is have an incident report created, filled out. Go get a manager or have somebody who's with you go get a manager and fill out that incident report. But you also want to get a copy of it. See, that's one of the problems is we have clients who go get a manager, the manager comes, he fills out an incident report, but the client doesn't ask for a copy of it. And even when the client comes and hires us, and we say we want a copy of it, what the stores say typically, or in a lot of cases, is, well, that's our quote-unquote work product, so we don't have to give that to you unless you sue us. And, so we can't get it initially. So if at all possible, you want to get a copy of that from the store before you leave. You want to get the names, addresses, and phone numbers of anybody who's a witness. And it doesn't have to be a witness who actually saw you fall. For example, let's say you slip, you fall, you're on the ground, and they didn't actually see you fall, but they come running over to help, and as you're talking to them and they're talking to you, and you realize, gee, look how wet the floor is, or look what's on the floor. And, oh, gee, where do you think that came from? Oh, it must have came from, this freezer that's leaking over here. And that witness is there to see all of that. Make sure you get their name, their phone number, their address, everything you can get so you're able to contact them later, because the store's not going to get that information. You're making a huge mistake if you think, well, I got a manager, he filled out an incident report, he must have gotten it. I can tell you in my experience, he'll never get it. So you want to get the name, phone number, and address for every witness who either saw you fall or came over and helped you. And then the last piece is, in this day and age with smartphones, if you've got one with you, take pictures. Take pictures of the spot that you fell in, the liquid on the floor, the freezer, or have somebody who's with you do that. Because what happens, unfortunately, in a lot of cases is this. Somebody falls down and they're embarrassed. And they get hurt, but they're able to walk, so they get up and they leave. And then it's the next day or the day after that that they realize, well, gee, I went to the doctor and now I need to have shoulder surgery. So now they want to bring a claim. But we contact the store and the store says, we've never heard of that incident. As far as we know, it didn't happen. We don't have any information about that because the client was embarrassed and got up and left. So you don't want to do that. Now, sometimes our clients are so severely hurt that the ambulance comes and takes them away. So it's not possible to take pictures, go gather the information for the witnesses, or do any of these other things. And and again, if that's the situation, then we just deal with it and we work forward the best we can. It's just important that you understand is all of that information is information that is really, really helpful to you when it comes to bringing your case, and it's really, really something that we do need if at all possible. I think those are the basic ins and outs. So thank you for tuning in today. I hope you have a great week, and until next week, take care of yourself.